Alex here with part one of the My Docket series on confronting Corazon real estate. This is the next My Docket thread, I guess you could call it, which goes into a complaint that I filed against a landlord called, or the organization, I guess it was an LLC called Corazon Real Estate. I want to mention straight away that this isn't going to be anywhere near as long as the High Conflict Child Custody series, which is a 226 part series. This one will probably be somewhere around 30 or 40 parts, I think. There is one hearing video only, which is an interesting video to go over, and it does cover the topic of civil litigation, which some people do ask questions about. If you want to go through my disclaimers, please watch the part 0 of the My Docket series. I know it's not technically in line with what's going on in this particular situation because it mentions the child custody stuff, but it does also talk about the educational purpose of these My Docket videos and this My Docket series. So again, definitely watch the part 0 if you haven't seen it yet, because at least the educational explanation of that video will apply to this new series of My Docket videos. Just sort of a rundown on what occurred is there was a broken air conditioner and the landlord repaired it and then billed me for it, which in Nevada is illegal. They're supposed to repair stuff that breaks down and not charging. That's, one of the landlord's obligations. The issue that I had is I believe that I still believe today that these types of practices, even if you confront them and stop it just for yourself, you're just going to keep doing it because of the explanation actually given in a very popular movie called Fight Club. There's a scene where he's on the plane and the guy next to him asks him, what's your job? And he explains, my job is to find out whether or not, let's just say car explodes, catches fire, whether or not it's worth it to recall all those vehicles, or whether it's actually cheaper to just let a bunch of cars explode and pay out money to those families who lose family members. Basically, it's a numbers game. Cars are exploding, people are dying, and it's going to cost, I don't know, $10 million per person that dies in the fire of a car explosion. But that may be cheaper than doing a recall. And if it is cheaper, that's what the company's going to do. They don't care that people are dying. So my opinion was similar to this situation here is if they are just making 1,000 different tenants pay to fix their air conditioner and like 3 of them sue them, they're not going to stop because they're profiting on the other 997 that are not, suing them, that are actually paying the money. The reason why I thought this was significant is because of a punitive damage principle called oppression. And this is something that came up in a case in Nevada where a casino was firing anyone that filed for workers' compensation. And it was actually not a secret. It was just their policy. If you file for workers' comp, you get fired. Anyway, the Supreme Court considered that to be oppression because people were only agreeing to it because they wanted to keep their job. They weren't agreeing to it because they actually thought it was right. And the opinion of the Supreme Court was that if you have power over a particular person, and if you are able to get them to give up their rights, not because they actually are okay with it, but because you have control over their livelihood and their wages, then that's oppression, and then punitive damages can be awarded. We'll talk more about it when I actually get to that point in the case. My perspective was similar with landlords, is that landlords are getting people to do things that are not legal, with people not necessarily agreeing to do the illegal thing and to give up money that they're not supposed to give up, but because they just don't want to lose their home. And so I felt like it was also oppression, and that's where this case started. That's why it wasn't filed in a small claims action in justice court. That's why I filed it in district court, because of the punitive damages process. In hindsight, see, this is kind of tricky. In hindsight, no, I wouldn't file it, but it's not because I was wrong, or at least I don't think I was wrong. It's because of how resistant the judiciary is to certain perceived cases. And it just makes it so difficult to go through the case knowing that the judge is just trying to find reasons to get rid of you and rule against you, even if it's not consistent with the law. And for that reason, it's something that as a pro se litigant, I wouldn't bother doing. Attorneys, it's different. As I've mentioned in a bunch of videos on the channel, attorneys can do certain things and get away with them because it's like, okay, well, that's their job. That's how the judge feels. They're an attorney. They went to law school. They have a law practice. Sure, it might seem kind of silly, but it's their job to do this stuff. That's why we have lawyers. But when you try and do it as a proper person litigant, you just get sort of a different treatment. They're just like, what are you doing? You're not an attorney. Go away. Unless it's something that's extraordinarily flagrant, they just try and get rid of you. And that's kind of the conclusion that I came to at the end of the case. And even today, I still have that opinion. If you want to learn more about that opinion, you can watch the video, Self-Representation Bias. But I think at this point, I've covered the background, and I guess I'll talk a little bit about my mindset. My mindset was mostly positive, because I felt like I was gaining a lot of traction in my child custody case, and I felt like this judge in this case would be a little bit better than the judges that I was dealing with in the child custody cases, because I had such good experiences with Discovery Commissioner Wes Ayers. And I sort of had the opinion that non-family judges were a little bit more wise about how they approach these issues. Ended up being wrong. This judge ended up screwing up, throwing the case out. I filed an appeal, won the appeal, but all of that stuff we're going to go through when I actually go through the videos, and you'll be able to see the whole process, the judge's perspective, my Supreme Court victory, etc., etc. So why don't we, at this point in time, go ahead and take a look at what I have filed. Here we have the complaint that I filed. I haven't looked at this before, so hopefully it's not terrible. If it is terrible, I'll tell you guys what I did wrong. Definitely take a look at my video, The Complaint, if you haven't seen it yet. That video explains the purpose of this document. I'll go ahead and mention briefly that this document is like a big box. And with this document, I put allegations to paper, and those allegations put things into the box. They will put targets into the box, the targets of the lawsuit, the people, the company, etc. And they will also put issues into the box, and those are the issues raised in the allegations. That's the purpose of the complaint, nothing more, nothing less. And so, let's see, I'm appearing in proper person here by complaint against Corazon Real Estate. So standard introductory paragraph, I'm indicating to the court that I'm representing myself. The parties. So here are the allegations that are going to put the actual targets into the case. This is going to give the court jurisdiction over the targets. Well, in part. So I mentioned myself, which I didn't even have to mention, but I did. As I mentioned in the video, the complaint, you who are filing the lawsuit submit to the jurisdiction of the court. So just instantly by filing this complaint, I've submitted myself to the jurisdiction of the court. I'm mentioning that I've resided here for the last 20 years. It does matter when you look at personal jurisdiction principles. It matters where you live. It matters where the alleged tort or breach of contract occurred. And so mentioning, where you've resided and where the targets of the lawsuit reside or where they do business is relevant and should be in the complaint as an allegation. And then we have defendant Corazon Real Estate. Henceforth, Corazon is a Nevada corporation. So that's a business entity. It's if I remember correctly, it's an LLC, but now that I'm reading this, it looks like it might be a corporation. So I might have been wrong earlier in the video. In any event, it doesn't matter because I have named the business entity involved, and just like that, the court is close to having jurisdiction over them. There's one more thing that I have to do to give the court personal jurisdiction over the target to the lawsuit, and that is service of process, valid service of process, which will come up later, I believe, in this video. Yeah, in this video. Relationship of the parties. So I'm alleging the dwelling unit is located, and then I give the address, which is also possibly relevant to jurisdiction, but I'm not sure that it matters since everything is pretty decisively Nevada, and so it's not really going to be an issue in this case. I've mentioned that I've resided at the unit as a tenant with a child. I mentioned that Corazon is the landlord when I resided at the unit. I've mentioned, let's see here, or I allege that sometime in November I sent a request to repair the stovetop because 2 of the 4 burners didn't activate. They made the repair. I allege that I sent a letter demanding $25 for an alleged no-show on the stove repair. That's interesting. It makes me think maybe they tried to charge me for a no-show when I was actually there. I allege that they repaired the air conditioner because it was sporadically operating. I allege that they repaired the air conditioner. They allege the filter was clogged, which did not fix the issue. I had them personally served notice demanding repair of the toilet. I'll continue. On July 18th, I allege that I sent a letter demanding the aforementioned $25 for the no-show plus $100.50 for repairing the air conditioner, which still did not work. Okay. And they threatened eviction and fines if I did not pay. Okay, I see. I'm alleging that they sent me a letter for the $25 no-show and for the repair to the air conditioner, which still didn't work, and that they threatened eviction if I didn't pay. This is very common, guys. There are rights in Nevada as a tenant that if certain repairs for essential things are not made, that you don't have to pay rent. And 99.9% of the time, the landlord responds by threatening to evict you. And a lot of times it works. People get scared. So even though you have the right to not pay rent because they're not fixing something essential, people will get scared. They won't want to get evicted. They won't know. Maybe I'm wrong about this. Maybe the judge will throw me out. Maybe the landlord can just throw me out without even getting approval. Maybe I have to get an attorney. All these thoughts scare people, so they just pay. And this is one of the reasons that I thought oppression was a valid assertion in this case, specifically under the punitive damages statute. In any event, I will mention a few more things. These are the allegations that I'm alleging, and I'm alleging these allegations very strategically, such that um, if they are true, I'm entitled to relief, and that's why I'm very methodical about, where I lived, who the landlord was, what requests for repairs were made, what actual repairs were made, what confrontations there were as to who's going to pay what. Each of these allegations has to be made to give the court jurisdiction over the issue that you're bringing to it. That's the subject matter jurisdiction piece. I don't know if I mentioned this, but if you guys haven't seen it yet, please watch the video personal jurisdiction, and then also watch the video subject matter jurisdiction. Each of these allegations is me trying to build a case, me trying to put all of these things in the box that gives the court the authority to actually do something for me. And so I'm putting the target to the lawsuit in the box for the court, and I'm also putting the issues of the lawsuit into the box for the court. On or around August 22nd, I reminded the landlord by telephone that the air conditioner still did not work. On or around August 24th, they successfully repaired the air conditioner by changing the thermostat. On September 1st, they made their first attempt to repair the toilet, and they were successful. I subsequently requested a rent credit due to the fact that I had to live with barely functioning toilet for so long, and they threatened eviction again if they did not receive rent in full. On September 7th, they cashed my rent check and served by posting on the door of the unit a notice of unlawful detainer threatening eviction for non-payment of rent. This is super standard. I talk about this in many of my other videos on landlord-tenant things. The landlord knows that what they're doing is wrong, but they threaten eviction anyway because it's such an effective fear tactic. It works so often. And so they do what they get away with. They threaten to evict you even if you are complying with the law. I wish there would be some statistics out there on just how often they get away with it, but I would suspect that it's like between 98 and 99%, because a lot of people are poor, they can't afford attorneys, they get scared, and they don't want to get thrown out. If you were to actually try and get somebody to pay something after they were already gone, that would be different. I would say, no way, there's no oppression there, because now you can't scare them with throwing them out of their home. They've already moved out. So if they were like, you know what, we're just going to leave this for now, we're going to set it aside until you move out, and then we're going to confront you on it, then I would say, no, there's no basis for oppression. I would say that's actually fair, because you get to live there, you move out, and then if you have a dispute, you're not going to feel like your arm is being twisted, that you have to violate the law, because you're already gone. You live somewhere else now. They don't have that power over you. But this is not what they do in Nevada. They do this while you are living there, and they basically leverage the fact that if you don't do what they tell you, they're going to throw you out on your butt. Next, we have the allegation September 12th at a summary eviction proceeding. I agreed rent was paid, disagreed that the maintenance costs were my responsibility. The court held that a summary eviction proceeding was not a proper proceeding in which to determine the merits of the legal defense, acknowledged whether a legal defense exists or not. The landlord persisted in its demands, and the court ordered that half of the demanded amounts were paid. This is what I call a meta ruling. So initially, I remember this pretty clearly. Initially, the summary eviction judge agreed that in a summary eviction case, they are not allowed to get to the merits of the case. This is something I talk about in the video Summary Evictions. Please watch that video. But the landlord kept on badgering the judge, and the judge said, okay, fine, just pay half of it. That's a meta ruling, and that is what I took issue with. And that's probably something that they had gotten used to doing for a long time. So whatever they were doing with all the other tenants prior to me, they decided to do with me as well. So basically, okay, fine, just get him to pay half, and just set aside kind of your legal training, the fact that you're a judge. And I say that not to be mean to the judge, but really anyone can do that. Any random person can do that. I can get my neighbor down the street and say, hey, can you rule on this case? And he can go, yeah, just both of you just pay, split it down the middle. You don't agree, you can pay half of it, move on. That's the issue that I had with that particular allegation, is that the actual coercion of the payment of that particular amount was made. And there's also there's an exception to, because some people might know about this, it's called claim preclusion or merger and bar. There's also another res judicata principle called issue preclusion. Somebody might say, well, hold on a second, if that judge ruled against you, there's nothing you can do. Actually, in Nevada, there is. In Nevada, there is a case that discusses the summary eviction process, and in that case, they create an exception to what I just talked about. And the reason they create an exception is because they have recognized that the summary eviction judge's authority is super limited. So because the summary eviction judge doesn't have the authority to go into certain issues that have to do with landlord-tenant disputes, the Supreme Court of Nevada has actually created an exception to those res judicata principles that allows you to come back to court in front of a real judge with actual real authority over those issues and have them make a decision on your case then and there. On September 13th, I filed a motion to void the judgment or the alternative stay pending appeal, and I attached the check in the amount of $105. This is the half the amount that the judge wanted. And then on September 18th, I filed a 30-day notice of intent to vacate the unit, basically voluntarily moving out. And then on September 19th, Corazon accepted the payment for $105. Here are the allegations on violations of law. So I went through the basic facts with the allegations all the way up to allegation 21, and now I'm going to go into the specific violations of law. So let's see. Landlord had a duty to provide a clean, safe unit for habitability, which included a sanitary toilet and that operates to remove human waste, air conditioner that functions to cool down the unit. I'm alleging that pursuant to the law, maintenance of the unit's habitability is the responsibility of the landlord, which is true. Next allegation is by intentionally disregarding statutory law and written notification and threatening and executing on its threat of eviction, the landlord is guilty of oppression and malice, more so oppression, less so malice, but I will discuss both as the case proceeds, and they are subject to punitive damages to deter such further conduct that's in the interest of the public. The landlord evicted the plaintiff without cause. The plaintiff had timely tendered all rent and was not in breach of any express or implied terms of the rental agreement. The landlord was in breach of the agreement by failing to provide for and maintain a unit that was inhabitable with all the utilities in working functioning condition, that none of the utilities and malfunctions were the fault of the plaintiff, and that was solely the result of the landlord's failure to maintain them in good operating condition, that as a result, the landlord persisted in threats to evict whenever I requested a maintenance repair or to exercise my rights under the law, and the landlord forced me to vacate the premises. Very common, guys. Again, I really wish more people would talk about this issue. Happens all the time. This is not the exception. This is the rule. And as a result of being forced to vacate the premises, that will uncover moving expenses. Next count is violation of another law, oppression and malice. By leveraging its position as a landlord and threatening and executing eviction upon the tenant for refusing to pay the air conditioner and maintenance costs, Corazon is guilty of oppression, malice, and retaliatory eviction and is subject to statutory penalties in the amount of $2,500. Next is violation of another law. Pursuant to the law, the repair should have been completed by August 7th. Therefore, pursuant to the law, I'm entitled to a prorated rent refund for the remaining 23 days of the month. My rent being $538.98 divided by 31 equals, and then I just go through the math of the prorate, which is a total of $399.89. So here I am requesting compensatory damages in the amount of $50.25 together with $10,000 in punitive damages. For compensatory damages for the no-show fee in the amount of $12.50 together with another $10,000 in punitive damages. For $2,500 in damages for retaliatory eviction, and then for damages in accordance with the law in the amount of $399.89 for moving expenses to be determined and for an award of interest at the legal rate. Interestingly enough, I think I mentioned the punitive damages under conclusion 1 and 2, but it may have been more appropriate to mention the general punitive damages award that can go up to $300,000. I know that this sounds like an insane amount for such a small infraction, but I make much more sense of why the law is in place if you watch the video Punitive Damages. It goes into detail as to why the government has decided that in certain situations, companies need to be punished not necessarily with the amount of damage that they're causing, but with the amount that's going to actually get them to stop doing the illegal conduct or behavior that they're doing. And that's all discussed in the video Punitive Damages. It's also a good idea for you to watch the video Compensatory Damages. I think it explains some pretty important tidbits in there as well. An award of costs and an award of attorney fees if retained. At this time I don't have one, that's why I put that in parentheses. Affidavit, I think this is actually supposed to be called a verification, but this is fine. All you have to do is swear under penalty of perjury that the allegations are true and correct, and that covers this document. Notice of extension of time to file an answer. Let's see here. Did they ask for one? Maybe because I'm moving out. I'm not sure if they asked her if it's because I was moving out. Anyway, I gave them a extension of time to file their answer all the way to November 8th with this notice. I probably didn't even have to file this. I probably could have just sent them in a letter or something, but I filed it. Next document is proof of service. So this is what gives jurisdiction to the court over Corazon Real Estate. I had a process server serve the Corazon Real Estate organization or corporation personally with the complaint. Notice regarding October rent and destruction of evidence. Okay, I know what this is. This is the fire insurance exchange versus Zenith case. Okay, if you guys want to learn more about what this does, please watch my video on the topic adverse inference rule. There's a video under the legal nuts and bolts category called adverse inference rule, and that explains what I'm doing with this notice. Basically, it warns them that if they destroy any evidence, that I'm going to see to it that the evidence that is destroyed is held against them at trial, and it's explained in detail in that video. I'm not sure that this needed to be filed. I probably could have just sent them a letter or emailed them. Filing it was a little bit extra, but back then that's something that I did a lot because I just didn't know. Rule 5 certificate of service indicating this document was mailed to Corazon Real Estate. Going into the aftermath, I filed 1, 2, 3, 4 documents, it looks like. Yeah, I filed all 4 documents. 3 of them were free, but the complaint I would have had to pay a filing fee for. If I remember correctly, it was, I'm just going to say $300 to file this. It may have been like around $270. It may have been $330, but let's just kind of round it off at $300 in costs to file the complaint. My opponent didn't file anything, so they didn't have to pay anything in costs. I didn't have an attorney, so I paid $0 in attorney fees. At this time, the Corazon Real Estate organization tried to deal with this without an attorney, but they ended up being forced to hire one later. That's going to be the subject of the appeal. So even though initially they don't have an attorney to review these, eventually they will be forced to get an attorney. And so for that reason, I'm just going to go ahead and count these documents now with regards to the attorney having to review them. The notice of extension is negligible, proof of service also, and the notice regarding the adverse inference rule. I would say all 3 of those will be 15 minutes. And then the complaint, that's going to be probably another 15 minutes, but then they're going to have to meet the defendant and at least do a little bit of a basic strategy. So I guess an hour to meet and then maybe a half hour to review. Let's just round this all up to 2 hours in attorney fees. At the rate of $250 an hour, that's going to come to $500 in attorney fees for the landlord. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.